Case is from right here in Sedgwick County. It is 126-164, entitled The State of Kansas versus Henry Edward Parker. And who do we have here for the appellant?
May it please the court, Clayton J. Ferguson appears on behalf of the defendant appellant, Henry Parker.
And is your name on the brief?
I'm on the reply brief.
On the reply brief. And for the appellee, Mr. Maloney.
Yeah, may it please the court, Assistant District Attorney Matt Maloney for the state.
All right, counsel, do you wish to reserve any of your time for rebuttal?
Yes, I would reserve 3 minutes for rebuttal.
That is granted.
And I intend to focus my argument today on issue 1 in the appellant's brief, which is the confrontation issue, and submit issue 2 on the briefing unless the court has any particular questions on that.
Well, my question on that would be, what's your best argument that you have preserved that argument?
I think that it is a fundamental right, and that the Hall opinion was able to address the issue based on the legal record and historical record of the Kansas legislature. So I think this court could reach that in the same way. Though I admit that in the Hall case that there was a motion on that.
Okay, thank you.
Turning to issue 1, as I looked at this issue, I thought it was kind of an excellent modern example of the harms that our framers included the confrontation clause in our Bill of Rights to avoid. This is a case where we have a person, who I'm going to refer to by his initials, DG, who gives a report to law enforcement claiming to be an eyewitness of an event and accusing Mr. Parker of being a shooter at this shooting at the park in exchange for a monetary reward. We then have DG refuse at all other instances to testify to anything regarding the case. He won't testify for the state regarding any of his statements to law enforcement, anything around there. He just says, I don't know. And he is at no point able to be cross-examined on any of his statements, his identification. Yet the error here, of course, is that his statement to law enforcement is then used as the building block, the foundation of this case, as the only person to have claimed to have seen Mr. Parker as the shooter here. The analysis for this issue is, I think, relatively straightforward. It's a Crawford confrontation issue. We have testimonial hearsay and then an unavailable witness, and the question is whether there's prior cross-examination of that witness. I don't think the state and I are even arguing over that many of the intricacies here.
Let me ask you a question.
Yes.
So there was a preliminary hearing in this matter,
Yes.
and try to DG testified at the preliminary hearing,
Yes.
and he said he didn't remember.
Yes.
And then the state stopped his questioning, and the court asked the defense counsel if he had any questions. And the defense counsel said, no questions. Is that correct?
That is correct, yes.
So wasn't that the defendant's opportunity to cross-examine DG and it was waived?
I do not believe so. I think the first question is whether or not DG was at that time an available witness for cross-examination. The state had called them on direct, and DG had answered, I don't know, to every detail, every question regarding the case. And I think what we get to in, I think the controlling case here is really the same example in Lomax and Williams, which goes back to 1980, but is like they say in the syllabus there, is the where a prosecution witness in a criminal action refuses to testify by responding to all questions with answers such as I don't recall or I don't know. His prior hearsay statements are not admissible because the witness is not available for cross-examination as required by defendant's constitutional right of confrontation of witnesses. And what we have here is a witness who was called by the state and was unavailable in the exact same manner there at both the preliminary hearing and at the trial. And when this issue was raised at the trial level, there was no dispute. There had been no prior cross-examination. The witness was behaving in the exact same way.
But doesn't the law say an opportunity to cross-examine?
Yes,
And so, I mean, in my experience, I've seen witnesses who are very reluctant to testify for the state or the defendant, but when the other party starts questioning them, they open up. There was no chance, the defendant waived that chance to find out whether or not he would or wouldn't say anything. Did the defendant waive that?
I don't think the defendant did, because I don't think the state had presented that witness as available for cross-examination on that. And the thing that keeps going back to in my mind is that the scope of cross-examination is defined by the scope of direct and what evidence was presented. And there was no evidence presented by the state with this witness who was unavailable. And the other analogy here that occurs in some of this confrontation case law is that a witness who, like in the Lomax and Williams cases, and those is sometimes referred to as being the same as not showing up at all.
You have a preservation problem even on this issue, don't you? In terms of making a contemporaneous objection at trial?
I don't believe we do have a preservation issue regarding this. First, I thought the way this was raised, I thought was the appropriate and contemporaneous manner to do it. The witness DG testified, that ends, the issue is raised as a confrontation issue, the district court rules on it, and immediately following that, the detective is recalled to bring in all of the exhibits that have been at issue in the case, including the recordings here. So this is, clearly this is raised at trial, is raised immediately prior to the state's witness that's bringing this in. The district court had the opportunity to rule on it. So I think under those grounds, it was contemporaneously raised, it was timely interposed as the statute requires. There was this.
But then when the officer testified and the actual testimony comes in, there was no objection or continuing objection or. In fact, I think for the exhibits, when they were introduced, I think defense counsel said no objection. Isn't that right? I could be wrong on that. But.
He did say no objection. It is a little bit messy. I would have preferred he said objection as an appellate attorney there.
Yeah, he should have said, I'm renewing my prior objection.
Yes. I think the no objection, there was another objection to foundation just before that with some of the exhibits, and he withdrew that objection. But we do have also the district court's statement in ruling on this that he says, I will restate the objection, and the district court did address grounds for admitting that evidence, which tied back into the district court's ruling there. The district court does mention hearsay there, whereas this was a confrontation objection, which gets into the State v. Jefferson, and I think there was some confusion there, though. This is a confrontation issue. It's objected to as a confrontation issue. We've raised it as that. I'm not sure how even as under the hearsay statute in State v. Jefferson this comes in, because again, that would have allowed in a transcript from the prior hearing, which is not what's coming in. This is the testimonial hearsay before any of it.
How significant is all this testimony? I mean, would your client have still been convicted even if this testimony hadn't have been allowed? There were lots of other witnesses, right? Or other witnesses at trial to tie your client into all this.
There are other witnesses at trial, though most of those witnesses were the law enforcement, not the identifiers. DG is the only person who at all in this trial proceeding claimed to have seen Mr. Parker as the actual shooter that day.
Wasn't there a witness, a co-worker that testified he admitted to her that he was the shooter?
There is a co-worker who said he made some of those statements. Though.
And isn't there another end? Okay, so that's another source of information that he was there. And then wasn't there someone else who saw a video?
The juror saw the video, correct?
Yes, there are videos, they are in the record.
But another juror saw a video on Snapchat and forwarded it to the police department and testified about that. Is that, of the person who was the shooter?
There was testimony from the people that took those videos. I don't believe they identified Mr. Parker as the shooter, the people who took the videos. One of the things, those videos are available, they're in the record. They are grainy, they are low-quality cell phone footage. They aren't, I mean, the state spent a great deal of time trying to argue whether or not you can really match up any details to those. It's a shooter, it's a person in a mask that is at such low quality that you can't really distinguish anything besides a general, it's a black male with a white t-shirt and jeans.
By a black Mustang?
I don't believe, or I don't
Or
think
did
there
that
was
come from the testimony of DG?
that came from the testimony of DG, I believe. I don't
Okay.
think, I'm not aware of anyone else who had talked about that on the record, though I may be mistaken. The thing I would say about the coworker's testimony is that is tempered by her own admissions of how Mr. Parker acted and talked at work, which included, I believe, a disclaimer about him being full of it. There are many references to him telling her false things about those nights and his life, including claiming to have sisters that he didn't have, claiming to be at locations he didn't have, claiming to have lived in places he hadn't had. He was making things up to her quite regularly, which I think is tempering. But I think the real question that this comes down to in harmless error isn't whether or not in a perfect trial removed from this error, the state could have theoretically convicted Mr. Parker. The question is whether or not this error in this case can be removed from having influenced the verdict here. And what the state did in this case is they relied on DG's statement. They relied on him as the first person they talk about in their closing argument for identifying Mr. Parker. The quote that they use, that they start off with, so let's talk about DG. Why should you believe him? And the state started their identification and framed their identification of Mr. Parker around believing DG's statements, who is an unavailable witness, whose testimonial hearsay was brought in violation of the Confrontation Clause. And for those reasons, I would request that you reverse Mr. Parker's convictions and remand for new trial.
I do have one question, going back to the Crawford issue.
Yeah.
So it's sort of unusual here, where the prior opportunity to cross-examine someone is at a preliminary hearing where the witness is unavailable because he refuses to testify. Are you sort of arguing in that situation then that our analysis sort of merges the two into one, of whether the witness is unavailable with the opportunity to cross-examine? Because normally those are two separate steps that we have to walk through in a Crawford violation case. Because you're saying under Lomax that if they're unavailable, then there is no opportunity to cross-examine it.
Yes.
And normally we're looking at if they're unavailable to testify at trial. You're saying he was unavailable both during trial and during the preliminary hearing.
Yes.
Okay, thanks.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. Beginning with issue 1, I think the questioning touched on what I consider to be the key topics on that issue. Our position is that there are 2 procedural hurdles that the defense simply cannot overcome to gain review of this issue. The first being the fact that he made no attempt to cross-examine this witness at the preliminary hearing. And Judge Schroeder pointed out something that was exactly what I was going to argue today, which is that We have all seen occasions where a witness is not forthcoming and might completely stonewall counsel for one party when questioned at trial or a preliminary hearing, but might answer questions when opposing counsel asks.
What is your best case that supports that argument? I'm looking at page 11 of your brief where you're talking about it. You cite State versus Noah, but it just seems to me that this witness obviously was not going to testify, and it would have been futile for defense counsel to stand up and try to ask questions. So I'm asking your best case on this issue.
There was no authority. There certainly, my research found no case where this particular situation played out. There are cases where it involved testimony where a person said, I don't know, but I did not find any cases where the party now seeking to raise a confrontation argument had failed to try to ask the question.
So your argument that defense counsel should have stood up and tried to ask a question, you're giving us no case.
I think it's a matter of first impression. There simply is no case law on it. So this is that case.
But you would agree normally for cross-examination, you have to have some substance to ask about and be within the scope of the direct, correct?
Well, and that's what I want to point out. I'm not suggesting that this should have been an onerous burden, that defense counsel would have been expected to get up there and ask 15, 20 detailed questions about, do you remember this? Do you remember that? All he would have to do, and I think this is similar to what happened at the trial, or also similar to what the prosecutor did at the trial, it would have been sufficient. I wouldn't be arguing that he failed to preserve this issue or that he didn't try to cross-examine. If he had simply gotten up and said, DG, you've answered I don't remember to all of the prosecutor's questions. Are you going to continue to take that approach if I were to ask you anything about, or he could have simply said, DG, do you remember anything about the night in question? I don't think it's too heavy a burden to expect for counsel to be able to ask one question to simply establish whether he will or will not. And I understand, Judge Malone, I understand your point that it is tempting to think to yourself that it likely would have been futile, but that does require speculation. We just don't know that that's the case. There are situations we've all seen from transcripts where a witness is much more forthcoming to one attorney than to the other. Clearly, DG had a change of heart between the time that he called police and gave these statements and the time that he appeared at the preliminary hearing. We don't know whether if the defendant's attorney had asked these questions, perhaps he would have even said, you know what, I think I was wrong. My statement was not accurate. I didn't see the shooter as well as I thought I did, and I don't think it was him. But again, that's speculation on my part, just like it would be speculation on opposing counsel's part or on this court's part to simply assume that he would have taken the same approach with defense counsel. And I don't think that that's appropriate when the case law does say you have to have been denied the opportunity. Well, when you don't seek to do anything, we don't know. He didn't take that opportunity. If he had done that, then I certainly would agree with the defense that he was denied the opportunity to ever cross-examine him about these previous statements. Second of all, we do feel that what happened at trial was not a contemporaneous objection. He objected while DG was on the stand and brought this to the court's attention. He did not request a continuing objection. The court did not sua sponte say that he had a continuing objection, and we've certainly all seen transcripts where judges might do that and say, okay, we've addressed this issue, and so in order to not have this have to be relitigated or hashed out in front of a jury, I'm going to grant you a continuing objection. And again, this is a minimal burden that the defense attorney had here. All he would have had to do is stand up and say, Judge, for the reasons that we just addressed outside the jury's presence, I would like to renew that objection. And that would have sufficed. But he didn't do that. when the detective testified. And as Your Honor pointed out, he actually affirmatively stated no objection when the exhibits themselves, the phone calls, were admitted into evidence. And so I think counsel, I appreciate counsel's argument on this, but essentially to me, it boils down to well, this was close enough. Because it had been addressed previously, that's good enough to preserve it. But I would argue that that simply is not consistent with our Supreme Court's jurisprudence. I think that especially in the 16 years now since King was released, our Supreme Court has been very strict in enforcing the contemporaneous objection rule. And while the objection in this case was specific, he did raise it as a confrontation clause issue when DG was on the stand. He simply failed to do anything to preserve that or renew that objection when the detective was on the stand and when the calls were played. And so I think that it would be really stretching far beyond what our Supreme Court has allowed to say that you don't even have to object at all when the witness and or exhibit is offered into evidence, that objecting during a previous witness's testimony suffices to preserve that. Our final argument would shift to harmlessness. Certainly, we don't dispute that these were testimonial statements. And if this court were somehow to overlook the failure to attempt to cross-examine at the prelim, then our position would be that even absent these statements, there was overwhelming evidence in this case. And counsel is correct that this witness was the only person who purported to see the shooter at the time. But we had the coworker, and she did see him on the video. She saw that video, and her testimony was that as soon as she saw the video when she was home watching the news, she immediately recognized him as her coworker. She then spoke to him about it at work, and he admitted to her that yes, he was the shooter. And in fact, he also told her, don't tell anybody. She then overheard him tell multiple other customers at the gas station that he was the shooter that night. So we have a coworker recognize him immediately from the video as the shooter. He admits to being the shooter to her, tells her not to tell anybody, and then he proceeds to tell other people. And then in addition to that, we do have the videos that were admitted in evidence for the jury to see. And I think it's significant that not only did we have the videos from the scene, which admittedly, it's not like it was a close-up shot of the shooter, but you do see him on there. You certainly are able to see his overall build, his clothing. You're able to see the lanyard that he has on him. And then you can compare that to the video from the gas station where you see the defendant up close and you see his clothing and you see that lanyard and you see his physical build. And I think when you combine those two things, I don't think there's any question that any juror looking at that would be able to determine that this was in fact the same person. Maybe if that surveillance footage from the gas station didn't exist and all you had was the Snapchat video and the video taken by the Facebook blogger, maybe you could argue there that it wouldn't have been sufficient in and of itself to identify him. But when you combine that with the gas station footage and then the co-worker's testimony and the defendant's own confessions to multiple people, not just to the co-worker, you've got ample evidence in this case that would have supported his conviction even had Gunther's statement not been admitted into evidence. And so our position is that even if the issue had been properly preserved, there is not a reasonable possibility that the outcome of the trial would have been any different had this statement been excluded. For those reasons, we would respectfully request that the defendant's convictions be affirmed.
Thank you, counsel.
Thank you.
I would actually like to read for just a second from the cross-examination of the coworker's testimony which is Volume 8. This is a question on page 130. The question is, do you recall testifying at the previous hearing in this case and were asked some questions about that Snapchat video, that you had watched it several times and that the person that's shown in the video could have been anybody? Answer: I said that I did watch it several times, yes, and it could have been anybody. And I think that illustrates the power of cross-examination and why it is fundamental to the truth-seeking role that trial plays. And that is the right that was denied to Mr. Parker in this case for the state's primary identifying witness. And that error that built this conviction is, we ask you to find, is not harmless. It prevented his right to a fair trial and ultimately requires his reversal of his convictions and remand for a new trial untainted by this constitutional error. And I am prepared to waive the remainder of my rebuttal time unless this court has any questions.
All right, counsel, thank you both very much for your briefs and your arguments. We'll get something out to you as soon as we can.